Somebody has picked up a video that I just made, and they've said that if people are welcome back in the UK despite being in Syrian prisons, then following the Trump administration's request, which has actually just been rejected, then could they be prosecuted in the UK for crimes committed abroad? The answer is, of course, yes, under the Terrorism Act. But first of all, citizenship is not just a legal statement, is not just a legal status, it's a cornerstone of personal identity and belonging. And in exceptional circumstances, many governments are in a position, or legally are in a position, to revoke that status. In the case of Shamima Begum, who left the UK as a teenager to join ISIS, exemplifies exactly this. Under British law, citizenship can be removed if it's for the public good, and the individual holds or is eligible for another nationality. The removal must not leave a person stateless, adhering to international law. In the case of Shamima Begum, I'm afraid that's exactly what's happened, because the other state to which she theoretically belongs won't accept her. That leaves her in a Syrian jail, and it leaves us in a moral quandary. Under the Nationality and Borders Act 2022, which is an act which was produced by Suella Braverman and one which I think should very firmly be repealed, it's made it easier for the Home Secretary to revoke citizenship without notifying the individual, escalating concerns about fairness and transparency. It's a dreadful law. And it's there to ensure the Rwanda Act passes through, and that people can be defined as illegal simply because of the route that they tried to come to the UK under. On every level, this is a law that shouldn't exist. The illegal migration law, which complements it, is also heinous. And then the Rwanda law is another law. These three laws, if Keir Starmer doesn't want to have the Rwanda system, he should be repealing all three laws. But he hasn't. So he's left us in a really interesting conundrum. I've always wished that I'd studied law. I recognise that, for the most part, law is a memory game. And to be messing around with law at this stage in my life, when my memory is not as great as it used to be, is a little bit of an absurd conundrum as well. But it's, I enjoy law. And I enjoy the complexities of it and the intricacies of it. And my particular interest, with a background in theology, is the morality of law. And there are many times when the law is simply wrong. And something may be legal, it may be illegal, but you then have to ask whether or not it's right. And Shamima Begum, who was stripped of her citizenship in 2019, presents a pivotal example. The UK government argued that her actions posed a threat to national security, but critics question whether a 15-year-old who was radicalised and trafficked should bear sole responsibility for what happens next, and indeed, where should she go? Do we not have a responsibility to ensure that if she represents a threat to our national security, she might also represent a threat to other national securities, and we should take responsibility for that. Her appeals have failed, with courts ruling that she remains eligible for Bangladeshi citizenship by descent, though Bangladesh denies this claim, effectively leaving her in limbo. And that is precisely what our legal system is designed not to do. Other countries such as Australia and several EU states also allow the revocation of citizenship for national security reasons. And in contrast, the United States, under its constitution, does not revoke citizenship from those born on its soil. Naturalized citizens, however, can lose their status for fraud or affiliation with terrorist organizations. Interestingly, it's the US under Donald Trump's administration that's pressured the UK to take back ISIS-linked citizens like Begum, framing it as a test of the special relationship. And while the UK has declined, citing security risks, this demand has exposed inconsistencies in how allied nations handle such cases and the US has refused to repatriate many of its own ISIS-linked nationals. The argument for revocation centres on protecting public safety and signalling that treachery has consequences. Critics, however, warn of ethical and practical pitfalls. This isn't about protecting Shamima Begum. This is about protecting the new state of Syria and about protecting our allies, in this case Bangladesh. Stripping citizenship often shifts responsibility onto other nations such as Syria or Bangladesh, which are ill-equipped to manage such cases. This out-of-sight, out-of-mind approach could exacerbate global instability and is not a mature approach for a mature nation like Britain. This is childish. Of course, I entirely understand how it took place under the leadership of Suella Braverman. But this principle of dual justice is there. Would a non-dual citizen committing the same act face equal punishment? And is Shamima Begum really a dual citizen? Does revocation create a tiered system where some are disposable and some are not? If citizenship is a contract between the state and the individual, and the individual breaches this contract, such as joining a terrorist organisation, there must be consequences. But the consequences are clear. That is about imprisonment. It's not about exile. And justice must balance security with fairness. And the UK must recognise it has a responsibility to other nations as well as to its own people. As the UK courts have affirmed, national security must remain paramount, but this should not override considerations of trafficking, exploitation, rehabilitation, particularly for minors like Begum. And it should not override our relationship with other countries like Syria or Bangladesh. The US pressures others to repatriate, but rarely acts on its own advice. While I believe Trump's administration was correct to suggest the UK take responsibility for Begum, it's imperative for the US to uphold the same standard, ensuring consistency and moral clarity. Stripping citizenship may be a legal tool, but it can easily become a political football. The UK and its allies must engage in a global dialogue on repatriation, rehabilitation, long-term security strategies, and how these impact other nations' development. To abandon citizens abroad risks both moral and strategic failure, and I think we've spent too much time thinking about the future of Shamima Begum and not about the future of Syria or the future of Bangladesh. We are undermining not only the principles of justice on which modern democracies are built, but the principles of good politics and good relationships on which the principles of international cohesion rely. We've got to be really careful that we do the right thing for Bangladesh and for Syria in relation to Shamima Begum. In relation to President Assad's wife, I think there's a much more interesting situation. I think it's wrong to leave her to languish in the hotspots of Rubliovka if she genuinely wants to come back to Britain. And citing Shamima Begum, the Shamima Begum case, as a precedent for her return or for her exile, I think is a very shaky grounds. Citing the fact that her passport has expired is equally shaky grounds and sets, again, a very worrying precedent. So this, again, is not about whether President Assad's wife has a right to come back to the UK. This isn't about her. This is about the precedent that denying her that right sets. By all means, bring her back and then put her on trial for the Terrorism Act 2000. She'll come back. She may even get hospital treatment, but she'll do it in prison. Because she is clearly complicit in the gassing of people and the behaviour of her husband, enabling the behaviour of her husband, whether divorced or not. And do British courts have the jurisdiction to prosecute individuals for crimes committed abroad, including membership of ISIS, Yes, of course, they do under certain conditions, particularly enabled by laws such as the Terrorism Act, which criminalizes membership in a prescribed organization like ISIS, regardless of where the offense took place. And I think we have a duty, if President Assad's wife wants to come back here, by all means, bring her back and put her in prison and awaiting trial, and see how the law courts deal with that. That is great. And by all means, give her medical attention. ISIS is a prescribed terrorist organisation under UK law. Joining it, funding it, or providing support is a criminal offence, whether in Britain or abroad. The UK law explicitly allows for the prosecution of certain terrorism and related offences committed outside the UK if the individual is a British national or resident. And trying individuals in their home country aligns with international law principles, avoiding problems like statelessness or indefinite detention for foreign prisons. And certainly President Assad's wife has links to the regime which should be held to account for its actions. It may not necessarily amount to terrorism, but it certainly amounts to genocidal acts and to war crimes. And as part of the administration, I think President Assad's wife could stand trial. And until that point, yes, she could be held in detention, and should be. And those are the terms on which her passport should be renewed. If she wants to come back to the UK, if she wants to divorce her husband, by all means. And the same thing should be true of Shamima Begum. We should not be exporting our responsibilities to other nations simply because that's convenient, or, quote, because this represents a threat to our country. We shouldn't be exporting threats to other countries simply because that is convenient. Sending British nationals to languish in Syrian prisons or allowing them to remain under dubious detention regimes such as Russia's Rubliovka or other facilities, because Rubliovka, yeah, it's a retreat for the rich, but getting out of Rubliovka would be as difficult as getting out of a prison. Believe me, I've been there. And it raises human rights concerns, and it risks fostering further radicalisation. Prosecution in Britain ensures a fair trial. Defendants have access to due process and legal representation. It ensures accountability where justice is served transparently, reinforcing public trust. And convicted individuals can be monitored, rehabilitated, or de-radicalised, reducing long-term security risks to ourselves and to others. And while prosecuting individuals in the UK is preferable, difficulties include obtaining evidence from conflict zones such as Syria, ensuring fair trials that meet British legal standards. But these challenges should not negate the necessity of dealing with returning fighters responsibly within the British judicial framework. And this approach avoids creating stateless individuals or, more importantly, exporting the problem to fragile regions or to other countries. We should deal with our own mess, and prosecuting criminals with ISIS membership in Britain is both legally sound and morally preferable to exile or abandon. And prosecuting people like President Assad's wife, if she wants to come back here, should be perfectly reasonable and on the table. And we certainly shouldn't be hiding behind some sort of bureaucratic nonsense that the passport office can't find her passport. The passport office has a great deal to answer.